Today we're diving into something that could cost Queensland sellers thousands if they get it wrong. Whether you're a seller, agent, or a buyer, this is something you need to know. Let's get into it. So what exactly is an encumbrance? Put simply, it's anything that affects the title or the use of a property. Things like easements, covenants, or rights given to service providers. Now, here's the trap. Some encumbrances appear on the property title. These are your registered encumbrances, like a driveway easement or a stormwater drain that runs through the land. Easy to find, right? But there are also unregistered encumbrances as well. These don't appear on title and they must be disclosed to the buyer. One of the most common examples we see, statutory easements for things like water, sewerage, electricity, or NBN cables. If these aren't disclosed before signing the contract, the buyer may be able to walk away at any time before settlement, of course subject to them showing their intention to purchase the property. But even if the contract is unconditional, that's not just a small issue, that can be a deal breaker. The standard form contract clearly outlines a seller's obligation to disclose matters affecting the property. In particular, sellers are required to disclose any encumbrance that will remain after settlement, including those not registered on title. This requirement is typically highlighted early in the contract with a cautionary note that failure to disclose may give the buyer rights to terminate or even claim compensation. Importantly, broader generic statements such as subject to statutory easements are not sufficient. That doesn't cut it, and the courts have made that quite clear. General wording will not protect you. Any encumbrance must be specifically identified, what it is, where it is, and how it impacts the property. So, how do you make sure you're covering yourself properly? Don't just rely on a title search. Do a dial before you dig search. It's free, and it shows the underground infrastructure like pipes and cables. Another option is to search your local council map overlays. Every council, of course, has different maps, but you can choose to view and see things it shows, like encumbrances, flood zones, heritage overlays, and even koala habitats. Seriously. If you find an encumbrance, specify it in the contract. Then include a clear description like sewer main traversing rear boundary, see attached map. And yes, attach the map, highlight the encumbrance, and have it signed by all parties. It sounds technical, but it's about being clear and honest. That way the buyer knows exactly what they're getting and no one's left exposed, and reduces risk of termination. If it sounds overwhelming, you're not alone. We review the contract prior to it being signed to make sure you don't run into any issues. Now here's the kicker. All of this is about to get even more important. From the 1st of August 2025, Queensland is rolling out the biggest change to property law in decades with the new Property Law Act. Every seller will legally need to provide a formal seller disclosure statement before a contract is signed. It's similar to what's already happening in New South Wales and Victoria by removing the buyer beware mentality in Queensland, which substantially changes the seller's disclosure position when selling a property. If you're buying or selling in Queensland and you want to make sure you're protected, talk to us at East Legal. Check out our website for more info, follow us on Instagram and YouTube for updates, and if you've got questions, just reach out. Thanks for tuning in. We'll keep you posted with the latest. I'm Courtney Lambert from East Legal, and we'll talk to you soon.